And welcome to Public Eye, that program where we have the opportunity of going through what the public has to say. I am Henry Igwibike, and this is Enterprise Television. Today, let's take a look at what Nigerians are looking at. That is a strangulation of the opposition. Is this opposition versus the APC? Is this Emilokan democracy? Now, let's stop lying to ourselves, ladies and gentlemen. What we have in Nigeria right now isn't democracy, as lots of people would say. It's a tight-knit fraternity masquerading as a government. Lots of people would equally argue. The moment President Bola Ahmed Tinubu arrogantly declared Emilokan, "It is my turn," the script was laid bare. It wasn't a call to serve, it was a hostile corporate takeover, lots of people would argue. We expected nepotism, creonism, and tribal godfatherism, other people would equally say. And brother, the administration hasn't missed a single bit of all of the things we've talked about. Now, let's fast forward to today, and the state of political participation is downright pathetic. The current dispensation has a weaponized political calumny, suffocating any voice that dares to disagree. But the latest stunt takes the cake, using a conveniently timed court order to delist vibrant opposition parties. Why? Because the establishment is terrified, people would argue. They know these alternative voices possess the grassroots momentum to trigger a political landslide in the upcoming general elections. Instead of beating the opposition at the polls, Tinubu's machinery, lots of people would say, chose to delist the names of the opposition from the ballot box entirely. Now, let's take a look at this from a very forensic context here. And I have joining me virtually Barrister Vanso Feli. Thank you so very much, Barrister, for joining us.
Thank you. Good afternoon.
Good afternoon. Thank you so very much for your time. So let's take a look at this. It's quite trendy, and lots of people would love to know how we can make sense of some of these things. Barrister, when you've learned of this new court order, what was the first thing that came to mind?
In fact, when I first got the notification, I didn't go to read it. I concluded it was fake news. So I didn't even open it because I considered it fake. You know? It was later on in the day that it began to gain momentum. And I got a notification from the traditional media. Because I first saw it from a blog and all that. Then when I saw it on the traditional media, I went to read the Guardian and I saw the full story. Then I checked a couple of other newspapers, and lo and behold, it was true. Now it's a surprising judgment because when this matter was filed first before the Federal High Court, the Federal High Court took a decision that led to the matter being taken to the Court of Appeal. And when it got to the Court of Appeal made an order, that they should stay action on the issue under reference until October. Okay? And that is the ruling of the Court of Appeal. So one would have thought that by so doing, the Federal High Court, will stay action, okay, led by Justice Peter Lifu, will stay action until that October. Okay, which you have the order. I have a copy of the order here. So, all of a sudden, the court sent hearing notice, I think 2 days ago, to the litigants, and then informed them that the court will be giving a ruling on the matter, and the judgment was delivered against a substantive order of the Court of Appeal. In law, the order of a superior court is binding on an inferior court. That is what they call hierarchy of courts. It comes with a lot of power, and then it is the precedent that we're taught, and that is what we met in our jurisprudence. It is therefore strange that you now have a court of appeal making an order and then the court below, the Federal High Court, disobeying the order. So the court below is in contempt of the order of the higher court. Now, going to the details of the matter, Section 225 of the 1999 Constitution as amended, laid down procedures under which INEC can deregister a political party. Okay. Now, one of the grounds under which INEC can deregister a political party is that if a political party is not able to win any seats from ward, to the state level to the federal level. So all that a political party needs to do is to win at least one ward, one councillor in one ward, okay, to be qualified. Because it is that provision that the courts use to make the order to INEC, and then to ask INEC to go and deregister the 5 political parties. Okay? Now, when you look at the 5 political parties under reference, ADC itself and the Zenith Labour Party and 3 others, these parties have at least one position in all the positions under reference, meaning that many of the political parties have crossed the threshold. So, having crossed the threshold by the Constitution, there is no ground or there is no ground upon which INEC should deregister them. In fact, in the same case, INEC had deposed an affidavit in that same case, stating that ADC and the other political parties have actually met the constitutional threshold to remain as political parties in Nigeria for the purpose of the 2027 election. So where the court got all this whole thing is where I don't know. Okay, I actually don't know. I'm going to tell you the truth.
Barrister, if as a custodian of the law you do not know, then how else do we explain this better? Lots of people have called it democratic home cleaning or housekeeping. And let's not forget, this particular section which you just mentioned, 225, was introduced by Ike Ekweremadu, and he said that it was meant to prune political parties such that we won't have so many of them on one list, and which will lead to a confusion. So the question now is, don't you think that all of this, as made possible by the court, is legitimate, knowing that none of the political parties were able to meet up to the threshold?
No. It's not a high threshold. It's not a high threshold. Because it is disjunctive. If you read it carefully, you see that the Constitution say must win this seat or this or. Now, if a political party does not have a councillor at all, it should have a state House of Assembly member. If it does not have state House of Assembly, it should have a federal House of Assembly or Senate. You understand? Or you might have one governorship or whatever. Once you are able to, the list in the line is councillor for a ward. So if a political party have that, and the political parties have it, and they depose to an affidavit wherein they attach the return, the certificate of return, to that effect. Okay. So when you look at it critically, you now begin to think twice. But I had searched through. I even called somebody yesterday because I needed to read the full judgment, because we also need to read the full judgment before we go criticizing and taking drastic positions. Okay. To find the ratio decidendi, what's it called? Ratio decidendi in law is the reason behind the judgment, the full reason behind the judgment, the ratio behind the judgment. So that's what I mean. So we need to also read the full judgment to find where the judge is coming from, because it's definitely coming from somewhere.
Yeah.
And then we can interrogate that place it's coming from and see whether it's in conformity with the law or not. So if it's not in conformity with the law, of course, the political parties, they know what to do. Because this judgment does not mean INEC will go ahead today and deregister those political parties. That's not what it means. The order has been made. The political parties will appeal the order. Okay? They will appeal the order. And once they bring an appeal within the time specified by law, within 90 days specified by law, then INEC will not deregister them because they will file a stay of execution together with a notice of appeal. So INEC will stay execution pending the determination of the suit or appeal. Okay. So and the political parties have all said they are going to appeal. I listened to Bolaji Abdullahi yesterday. I also listened to uh, the presidential candidate of the Zenith Labour Party, okay, and legal advisor to the ADC, okay, and the same position across board, that the judgment is one that came with a lot of shock, that if the judgment is allowed to stand, it will hamper and weaken democracy, that if we do not fight against this judgment, it has a tendency of destroying the democratic process. I want to call on the judiciary. This is the time we have to be very careful. Okay, we have to be very careful with our democracy, our hard-earned democracy. We know how long it took us to come here. Okay, we have, we have taken so much. Okay, and now we are coming from so much. So it's a time where the judiciary has to be circumspect. Think through carefully. The laws are very clear. They are not ambiguous. You can apply them according to its dictate. Okay, that is what is required of us at this stage, because opposition is the strength of democracy. If you don't have opposition, then the ruling party will go to town to do whatsoever it likes, and then there will be no check and there will be no balances in power. So that the call to do the right thing at all times is very critical. I think that the political party, as they have said, they will appeal this judgment. I do not agree. At the risk of not taking side holistically and completely, having not read the full judgment, I do not think I agree with that judgment.
All right. Of course, let's not forget that the Constitution commands what it commands until it is amended. Let's talk about timing now, especially Oshun governorship election is coming Ekiti equally. It's right about the corner. And you talked about 90 days. Time is of the essence. Do you think they have more than enough time? Do you think there's time luxury at this point to do the needful and possibly help save democracy?
After every judgment, okay, the judgment debtor have 90 days within which to appeal. It doesn't mean it's going to wait until 90 days. As I'm talking to you, the ADC, they say they are filing their appeal today. Okay? So it doesn't mean you're going to wait 90 days. That's the window you have. Okay? If you don't bring the appeal within that window, and then you want to file outside 90 days, you have to seek the leave of the court to do that. You understand? But now appeal is of rights. So they are not waiting for the 90 days. Because even if you look at the election calendar and everything, they are not waiting for the 90. And a lot of people have gone to town to say that ADC have been deregistered. It has not been deregistered. There's a court order. A court cannot deregister a political party. The constitution says INEC. So that's why the court made an order that INEC should. You understand? But when I went on Twitter, what I was seeing there, Nigerians, I don't know how to explain to the public. The ADC has not been deregistered. There's a subsisting court order. And once there's a court order, that is the law until same is upturned by a higher court. Okay? But the fact that the judgment will be given does not mean it will be executed immediately. Once appeal kicks in, execution can no longer take place until appeal is determined. So that is what it is.
Of some of these things, and if we can go historical for a bit here, and we have it that the fourth alteration to the Constitution, number 9 Act 2017, which introduced section 225A, which was championed at the National Assembly by Senator Ike Ekweremad at the time with the PDP. Do you think the APC possibly is repeating the same thing, knowing that they are the ruling party, and therefore they will do everything possible to ensure that the opposition does not see any light at the end of their tunnel?
It's not the APC. APC have no business in this whole thing. It's the
Really?
court versus the political parties. The court is the one that gave the judgment against the political parties. Okay. So if you say APC, that one is you are saying that APC influenced the court. That's what you're saying, right?
Yeah, possibly, because this is public eye, and we look through the lenses of what the people are saying, and from that we made that premise.
Yeah, the premise is a conjecture. Not like it's impossible. Not like it's impossible that the political party or ruling party cannot influence what is going on. It's not impossible, but it's not watertight. You don't have the evidence to establish that. You can't use conjecture or suspicion. Suspicion and conjecture cannot take the place of evidence. Okay? You know, the party that brought the action is one organization they call former lawmakers. You know, we know that, we know all that. But for the sake of sanity, okay, even if the ruling parties try to influence the court, assuming we're not considered, it is not in the place of the court to cave in to that. Okay, assuming we're not considering that, you know, the ruling party's hand is in this. It is for the judiciary to ward it off and look at the law and stand by what the law says. And what the law says should be final and nothing other thereof. Okay? So the postulation in town cannot become the yardstick or the basis for analysis, you know, of this nature, that is required a high sense of objectivity. You understand? Yes, because yes, the media cannot take side too. If the public have taken side, the media cannot take side. The media can suspect foul play, but it must limit its reportage, you know, to what is just, fair, and objective. It cannot be swayed by the public and then go into, you know, because the people making comments, public are different. People are talking based on their level of knowledge, and they are making, you know, expressions. Many times the expressions are not backed up by evidence. And even if a matter is true, but it fails the test of evidence, it cannot be held to account. That's why the Supreme Court will say this case looks up to the high heavens for want of evidence. Even when the court suspects foul play, without evidence, the court cannot act. So that is it.
The NJC at this point, a petition has gone to them. Do you think anything good will come out of that? And what do you think is the state of the NGC as it stands today? A lot of people have called it a dog that barks that never bites.
No, the NJC discipline judges. They say they're going to send a petition against Justice Peter Lifu
Yeah.
for the judgment on that reference. So the NJC will investigate, and the NJC will do its job. It will look at the judgment, look at the law and all that, to do what it has to do. If it finds the judge wanting, it will definitely penalize the judge. Okay, but not until their findings are clear on evidence. Their findings are clear on the rule of law. Okay, it's the rule of law we're talking about here, which is the backbone of democracy.
Act 2026 and concluded its primaries thereto be deregistered. Another question people have asked is, can a lower court go ahead, like Barrister had said, go ahead to deliver judgment in a matter where a higher court, the Court of Appeal, has reportedly ordered a stay of further proceedings pending the determination of an appeal? People have equally asked other questions like, can a suit allegedly initiated by party whom have not suffered any legal consequences or shown any legal standing proceed to determine the fate of the existence of a political party in Nigeria? And lastly, another question the public had equally asked is, can a political party certified by INEC as meeting constitutional threshold be declared non-compliant under Section 225A of the Constitution? This and many more questions Nigerians are asking. Barrister, before we conclude for now, what do you think is your last thought on this? Do we hope to see an appeal that would favor the opposition as we move forward?
We cannot preempt the court.
Okay.
Yeah, they will just go on appeal, and the appeal will determine the next step. But I want to answer that question from the public that someone said that can a political party that is certified by INEC in its affidavit, whether it can be deregistered and all that. The fact that INEC have it in the affidavit that the parties have met the threshold, okay, does not in any way INEC's expression cannot be taken above court order. Okay. INEC, and because and I want an affidavit. An affidavit is a statement of fact or truth that a person deposed to within his knowledge, okay, or an institution, or a person deposed on behalf of an institution, or on behalf of himself, or on behalf of another person, believing same to be true as at the time of the deposition. So it's an oath, okay, but it doesn't mean such deposition cannot turn out to be wrong. In the case of that reference, I'm not saying that the INEC deposition of certifying those parties as having met the threshold is wrong. I'm not saying that. But I'm saying that the orders of court supersedes the affidavit of a litigant. Okay? So let us go on appeal. The Court of Appeal will determine whether Joseph Lifu is right or wrong based on the grounds of appeal and the particulars of error. So if the particulars of error are such that the Court of Appeal do not agree with, then there's no way the Court of Appeal will uphold the judgment. And that's the reason the appellate court exists. They can take this all to the Supreme Court. Okay, because the appellate courts are courts of policy. They will give it priority, given that the election is just by the corner. So if they all file, the Court of Appeal will hear it as quickly as possible. And if they are not satisfied, they can go to the Supreme Court, and the Supreme Court will determine the matter within record time so that all the political parties will know where they stand.
All right, that's awesome. And the truth is that when it comes to anything that concerns the public. It's two sides of the coin. While so many would ask a very fascinating question to appeal to what they stand for, others would love to go against. And I have this one from someone who might not tally with all the questions I have asked. And this person says, the law is the law and the Constitution is supreme. If a political party has demonstrated or failed to meet the minimal electoral threshold set by Section 225, it is not persecution to delist them. It is constitutional fidelity. Barrister, do you buy that?
Very well. That is the truth. It is constitutional fidelity. I think that person must be a lawyer. It is constitutional fidelity to uphold the rule of law. It's not the court. If they did not meet the threshold,
Yes.
But they are saying they have met it, and that in the case they depose an affidavit and they attack the certificate of return of the political party. Because what the Constitution says that you must have won. Many of these political parties, they have seats they have won, even though their candidates no longer in the political party. Many of them move to APC, move to whatever.
Yeah.
But when you move, it's not you that won the election, it's the party that won the election. So the party still have the certificate of return from my neck. It stands. It does not delete or nullifies the fact that you won that election at the time. You have crossed the threshold. And so those were the certificate of return that were deposed to in that affidavit. Okay. So that when they say, because if it turns out that truly those parties do not meet the threshold, it should not be said that the court registered them. It should be said that the court made an order to INEC to preserve the rule of law.
Wow, that's a very tough one there. Of course, this is ongoing, and right here on Enterprise Television, the public eye, our searchlight would be directed on everything the public is saying, and we hope to bring them here, filter them, bring in experts to digest them, and hopefully we might all make sense out of every single one of them. Thank you so very much, Barrister, for your time. Truly do appreciate your insight.
Pleasure.
All right. Okay, that's our time for today on the public eye, and I love to believe you enjoyed our show for today. The story goes on, and like I did say, we would be here to bring them to you as they unfold. My name is Henry Igwebike. Meanwhile, please do well to be part of the show. Go to our comment section right now, put down